of us.
Well, at my age, it does anyway.
Very good. Mr. Skelton, we are ready to proceed. Everyone's here, so have at it.
Very good. Thank you, Your Honor. I represent the appellant, Koch Investments Florida, LLC. Before I begin, I would like to reserve 5 minutes of my time for rebuttal.
Very good.
This case comes before the court from the denial of Koch Investments 1540B4 motion, in which it alleged that I'm sorry.
Oh, no, please continue.
Can you hear us? I'm sorry. So in which Koch argued under the motion that under Florida Statute 48.23 paragraph 1D, that court did not have subject matter jurisdiction.
Let me ask you a question about that statute, because we're familiar with the record and we understand the chronology and the background. The statute itself, and I want to talk about the part that I think is at the heart of your jurisdiction argument. It says that except for the interest of persons in possession, the recording of notice in this instance of the Liz Pendants by Bank of New York constitutes a bar to the enforcement against the property of all blah, 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 of other unrecorded interests at the time of recording. With respect to your jurisdiction argument, I'm struggling with two parts of that. The first is I don't see how this statute anywhere in here that it says anything about jurisdiction. What it says is it bars the court from enforcing, and the trial court would have to exercise jurisdiction to either enforce or decline to enforce a lien, an unrecorded interest. So that's part one, and perhaps you can address that so I don't ask you a 12-level compound question.
Okay, very good. Well, I would have to refer you to the fourth DCA's case of U.S. Bank versus Quatermain.
So Quatermain, but we're not bound by Quatermain.
Correct.
Assume for purposes of this discussion that we don't necessarily agree with that. And I'm not sure, by the way, part of the reason I'm asking you this question this way is that while Quatermain recites the argument that the appellant in that case made about lack of jurisdiction, I'm not sure that was their precise holding, but we can put that to the side. Just assume for a minute that we disagree with Quatermain, and which we're entitled to do. And tell me how this statute strips the second court of jurisdiction as opposed to limits what it can legally do with respect to a later filed or later recorded lien.
Well, I guess the question would be, what would be the effect if the trial court in the Cruz Bay matter was to, as it did, render a final judgment and have a sale, and thereafter, as happened in this case, the court in the Bank of New York matter had a final judgment and a foreclosure sale. Does that, because the Bank of New York matter wound up to a final judgment, does that then vitiate the ruling of the...
No, I mean, look, as a practical matter, just looking at this from the perspective of a title underwriter, what Bank of America has is a superior claim by virtue of whatever it's going to, by virtue of its recorded mortgage and whatever might happen in the action that is the subject of the first action. So the other thing I wanted to talk to you about with jurisdiction, and I think we have some more questions for you, so I don't want to spend all your time on this, but your argument is cast entirely in terms of subject matter jurisdiction. And your opponents didn't really, I don't think anybody argued this, but another question, I don't want to sandbag you, but I just, for the sake of discussion, I'm going to ask you this question. Is this subject matter jurisdiction or is it procedural jurisdiction?
Well, that's a good question. I mean, and I'm not sure that the courts that have heard this have really made that distinction per se, other than, again, going back to...
And the reason, let me tell you the reason I'm asking, because, like what you're describing to the trial courts, we are also guardians of our jurisdiction. And we start with, what jurisdiction did the Constitution give us and what jurisdiction did the legislature prescribe consistent with the Constitution? Here, the Constitution gave the county court's jurisdiction as the legislature might prescribe. And what the legislature prescribed was jurisdiction for, and effective 2021 cases up to X $50,000 and so on the tiered thing. So that's subject matter jurisdiction. And I don't see how another statute in the real property scheme could operate to deprive the court of subject matter jurisdiction. I do see how I'm amenable to a procedural jurisdiction argument, although I'm not sure for the reasons we discussed earlier that it flies. And I want to ask you another question. I don't think you need to spend a lot of time on procedural jurisdiction because I don't think it's been argued, but I just wanted to make that point that I question the whole basis of a subject matter jurisdiction challenge. The statute itself speaks of, in two places, of the first place is in about the fourth sentence down, a lien or an interest unrecorded at the time of recording the first lis pendens. Unrecorded is different than non-existent. And where I'm going with this is how does your argument, if we play the tape to the end, how does this hold up for anybody who would become a creditor that could have a lien interest after 30 days of Bank of New York filing its foreclosure action? This seems to contemplate interests which exist but are not recorded at the time of the first filing of the filing of the first lis pendens. I'm struggling with how to apply this, particularly given the text, which twice refers to unrecorded interests and liens. It doesn't refer to non-existent ones, and the implication is that unrecorded exists but hasn't been recorded.
Well, that's true, and I'm honestly struggling to understand what your question is to me. I mean, if it's a question of, is this a statute of repose?
My question is, how does the statute apply to an interest that doesn't exist for way longer than 30 days after Bank of New York records its lis pendens? There's nothing in here about non-existent interests. It's talking about interests that are unrecorded at the time.
Well, unrecorded at the time also contemplates ones that are not in existence in my mind. I think it contemplates both. But if your question
Can I
is—
ask you one question, Mr. Skelton?
Absolutely.
That might get us back where I'm being helped with your argument. Was the lis pendens filed in this case? Are you dealing with strictly an equitable lien that was recorded at some point after a lawsuit was adjudicated?
Well, Cruz Bay did not file a lis pendens. Of course, there was a lis pendens filed in the Bank of New York matter.
But did the grounds for lis pendens exist at the time of the equitable lien?
Well, it wasn't based upon a recorded document. Therefore, I think it would be subject to dismissal under the statute. But is it possible they could have filed one? I suppose it's possible. But again,
well, I would have put a cloud on the title. I would have messed things up and given them a chance to intervene in the original action.
Well, it certainly would have clouded the title based to the detriment of Bank of New York.
All right. Well, I probably got you off a far field. I apologize for that.
Well, it's probably more my lack of understanding of your question, Your Honor, quite honestly.
Oh, you're doing fine.
All right. So again, as the court, I think it pretty well understands the issue. The issue is, does the application of this statute, the fact of this case, result in a finding that the Bank of New York court, from which the lis pendens was created, have exclusive jurisdiction to adjudicate the unrecorded equitable lien claim of Cruz Bay? And the answer to that is yes.
Well, wait a minute. The legislature, the Constitution and the legislature following the Constitution gave the county court jurisdiction over a lien claim in this amount. That's subject matter jurisdiction.
Well,
and
yeah.
The legislature didn't purport to take that away in the lis pendens statute by saying something like, even if the the court of the original Liz Pendants would not have subject matter jurisdiction as prescribed. They will now.
Well, I think
Purposes of compliance with this statute.
I addressed that in our briefs, and I pointed out that I set forth what the jurisdiction of the county courts were, and there is an exception in there for statutes that basically take away that jurisdiction.
But this one doesn't. It doesn't say, the word jurisdiction doesn't appear in chapter 48, or at least in 48.23, subsection D1.
Right, those words don't appear, but it does say that it bars the enforcement. So what does that?
But to bar or allow enforcement contemplates having jurisdiction. So it could bar the enforcement by a county court, and if the county court improperly enforced the lien for some other reason, then it wouldn't be a question of jurisdiction. It would be a question of legal error based on following the statute.
Well, again, let's get back to the practical problem. What you're arguing is, let's assume that the county court did have jurisdiction. Again, what happens to the Bank of New York case, and what happens in this case? I mean, we've
already talked. That's a matter of what gets recorded in the public records as to this property. Let me ask you a slightly different question. Your opponents have argued caveat emptor, of course, and it struck me in reading the record that Cruz, a month or so after the stipulated judgment was entered, recorded a notice concerning the Bank of America action. And that was in February, and the sale didn't happen until May. So Coke comes in May. It's certainly charged with notice of what's in the court file here. And it was also, based on a wealth of precedent, I think, charged with notice of the Bank of New York lien and foreclosure action, because those were all items that came up through a public record search with vis-a-vis the Liz Pendants, et cetera. So what exactly, I mean, isn't this just Coke asking, I bought a pig in a poke because I didn't check beforehand, even though all the information was there. And now I would like out of the pig in the poke and give me back my $150,000, let me go on my merry way.
Well, that might be true, but for the fact that if in fact the trial court had no jurisdiction, then there was no benefit of the bargain.
Well, I mean, for purposes of my question, you need to assume that you and I disagree on the lack of jurisdiction. And I'm getting down to the brass tack of, let's assume the trial court could do this, and how did they err by doing it?
Mr. Skelton, if I understand what you just said, is that if there is jurisdiction, then Judge LeBrit's hypothetical would apply, that your client had notice, or had at least constructive notice of the existence of the Liz Pendants. So I guess I want to give you the chance to clarify that, because if the court has jurisdiction and cannot enforce a new judgment on equitable lien, aren't you then relegated to challenging the sale simply based on equitable grounds? And then you have to deal with the fact that your client knew or should have known that there was a problem.
Judge Silverman, I will concede that if this court finds that the county court had jurisdiction, that Cruz Bay had at the very least constructive notice of the existence of the Bank of New York lien, and under the recent precedent that this court set, and I think the case of Quest Systems versus FAR, we would be unable to make an equitable argument based solely on that.
All right, so I just want to make sure then you are limiting your argument to one of lack of jurisdiction.
Correct.
Okay. And you have a minute left before you get to your rebuttal time, so I just wanted to give you that warning.
That's fine. I mean, at this point in time, I'm willing to further engage in any questions the court might have. Otherwise, I'll reserve my time for rebuttal.
Very good. Then you've got your 5 minutes for rebuttal.
Thank you.
Thank you so much. I'm not certain who's going to argue next, so I don't know if you all have talked about that, or if you're both arguing, just let me know.
Yeah, Your Honor, Matthew Wolf, for the appellee, HTN Trust. We're going to split our time. I would like to try to take 12 minutes, and Mr. Delatour will take 8 minutes.
Very good.
Will you notify me of the 12 minutes deadline, or should I keep track?
I'll let you know.
Thank you very much. So may it please court, Matthew Wolf on behalf of HTN Trust, the defendant in the underlying matter. There's two issues that Mr. Delatour and I want to talk about. First is the issue of Quatermain versus Jalali and its application to 48.23. And then Mr. Delatour is going to touch on a third-party purchaser's ability even to contest the underlying judgment and foreclosure. I know you're familiar with the underlying case. The motion that Mr. Skelton filed was predicated on this idea that the ruling in Quatermain limited the jurisdiction of the court. And we responded by citing to the Jalali matter, which discusses when you're foreclosing against a homeowner. And Mr. Skelton makes this argument in his brief that the Jalali court misspoke when it discussed the Quatermain case, that the Quatermain case was a foreclosure against the homeowner, which would be similar to what took place in Jalali. I went through painstaking detail in my brief to distinguish this. I think his factual analysis of Quatermain is incorrect. Quatermain was a case where a homeowners association attempted to foreclose out the first lien, which was U.S.
I'm sorry, Mr. Wolf. I think we can agree that neither Quatermain nor Jalali is directly on point here, given where the players were and how the Fourth DCA reasoned the distinction of Quatermain in Jalali, going back to the recorded the deck. And I think that fact was probably present in Quatermain as well, but they arrived at, they analyzed the case differently, probably based on the arguments the lawyers made. But that doesn't, we can talk about Quatermain and Jalali all day long, and it, other than what I think is sort of a fleeting reference to the argument that was made in Quatermain, I don't think any of that really helps us. I'm not sure that Quatermain holds unequivocally that the later court lacked jurisdiction. I think they recited the existence of that argument. And I go back to what the statutory text is in 48.23 that simply says, assuming there's an interest that's within the meaning of the statute, which is another point we need to talk about, but assuming that there is one, it bars enforcement. It doesn't go to jurisdiction. So tell me why the Quatermain and Jalali even matter is really.
Yeah, so I don't think Quatermain matters. I think Jalali matters for that fleeting reference that you mentioned earlier in the second to last paragraph, which discusses what the purpose of the list pendant statute is for. And the court clearly says the list pendant statute is there to protect the lender, the party that filed the list pendants, and not the homeowner. It's cited in my brief multiple times, and that's what we argued in the trial court. Now, Judge Labrador, I agree with your assessment of what 48.23, or at least your questioning earlier of what 48.231D says. It discusses unrecorded interests that are in existence at the time that list pendants is filed. It does not address interests which accrue at a later point in time, which would make sense when you read it in conjunction with the Jalali opinion that says the list pendants statute is there to protect the lender. If you're a lender and you're foreclosing, first thing you do is you order a title report to determine who has interest in the property. You want to name everybody who has a junior interest so you can have clear title.
And then 30 days later, you order your update and amend your complaint. I know that.
Exactly. And you're giving everybody out there, hey, you've got 30 days. If you've got some interest that you want to assert in this property, you have to intervene in that 30 days. Otherwise, I get to proceed forward without having to worry about anybody intervening in my case and attempting to take my position. It doesn't address what would happen at a later point in time if an interest accrues against the homeowner. And I went through many examples in my brief I think a
No,
great
and-
example.
And this is really for the benefit of your opponent on rebuttal. If the legislature had meant for 48.23D to confer exclusive jurisdiction on the foreclosure court, why would they put in the 30-day limitation? Why wouldn't it just be an open-ended deal?
Well, I think that's to protect the lender from.
And like I said, that is more a rhetorical question for you and when I want your opponent to be ready to answer
Right.
on rebuttal.
So but I went through multiple potential issues I see if you agree with Mr. Skelton's analysis of 48.231D. One of the biggest issues I see is something like a code enforcement lien. This is typical. You see a property goes into foreclosure. A year later, that person's not taking care of their property. You have a municipality who they have the ability to fine for failing to follow.
Mr. Wolf.
Can you hear-
Maybe you mute yourself and then come back, unmute it. Let's see if that fixes it.
Can you hear me now?
Nope.
No?
I can.
Okay, I can hear you now.
Okay. Property falls into foreclosure. The party who owns it isn't taking care of the property. They're violating local code enforcement. What are the municipalities do? They start fining these homeowners. If these homeowners don't comply, what do? They file a claim of lien, and they then foreclose that lien if you're not in compliance. In the Jalali matter, that was a 5-year foreclosure. You can imagine all types of things that could happen during 5 years that would affect the homeowner's interests. And so now you're saying now our code enforcement, you lose jurisdiction because you didn't have an interest at the time the lis pendens was filed. Therefore, you couldn't have intervened in 30 days. And if it happens a year later, now you can't enforce this against the homeowner. That would fly in the face of what the purpose of the lis pendens statute is for. It's to protect the lender, not the homeowner. Another example would be, properties in foreclosure. You've got a hole in your roof. It's a 5-year foreclosure. 1 year in, you hire somebody to fix your roof. You don't pay them to fix it. They record a mechanics lien. Mechanics lien has a statute of limitations of 1 year. So if that mechanics lien can't intervene in that foreclosure, and that foreclosure happens for 5 years, that mechanics lien just has to sit there and they can't do anything. They can't enforce interest. What happens if that homeowner modifies their loan and that lis pendens gets dissolved? That mechanics lien is never going to be enforceable. All you're doing, if you're using Mr. Skelton's analysis, is you're protecting the homeowner. You're not protecting the lender. If you read this to say that if there's an unrecorded interest at the time the lis pendens was filed and they need to intervene, and that's it, that protects the lender. If you read it that it goes perspective as long as possible, even if the interest is against the homeowner and not the borrower, you're protecting the homeowner. His argument is doing nothing but protecting my client. And that's why I think Jalali is important, because of that distinction of what the purpose of the lis pendens statute is. Mr. Skelton argues that now there's going to be a cloud on title because his client would have received title versus what was going to take place in the U.S. Bank. I think this is a manufactured issue. We see this all the time.
Mr. Wolf, I don't think you need to argue that. I think that is, as a matter of law, a subsequent lien is going to be wiped out by the prior lien holder in the lis pendens, period. So to me, I did not find any reasonable basis for that argument that there's some confusion. There might be confusion of somebody who isn't looking at the record, but that's as a legal matter, not an issue.
Right, and I agree. We see that all the time. And as Judge LeBret talked about, the parties agreed in the situation that everybody's interest was junior to the first lien. Nobody was asserting a claim or a right against the lender in this situation, where, as opposed to Quatermain, they were. This is why it was addressed in the stipulation. I imagine this is why the plaintiff filed a notice, putting everybody on notice that there was a senior lien outstanding there. So anything that would have happened would have been subject to that first mortgage foreclosure. And in fact, Mr. Skelton's client took title in this case because his objection was overruled. And so he received it. One of the things I did in my brief is I cited a paragraph from the Jalali brief that was filed by the Homeowners Association. And it discusses that if you read the statute as Mr. Skelton does, what that does is parties who don't have an interest at the time the lis pendens was filed, but may accrue one at some later point in time, a year later, they will have to intervene in the case just to protect their interests. And that would be a waste of judicial economy. That would be, and the quote, the part I cited says it will be a sanctionable action by these parties. And I don't believe that's the purpose of the lis pendens statute. The lis pendens statute is to protect the lender, and it's not to protect the homeowner. If the court doesn't have any other questions, I think I'll let Mr. Delafleur. I'm not sure how much time I have left.
You have about a minute and a half, but I don't see anybody getting ready to ask a question, so we'll accept your turning the microphone over.
Thank you. I appreciate it.
Thank you, Your Honors. May it please the court, Eric Delatoile here on behalf of, the co-appellee Cruz Bay Properties. Your Honors, what I'd like to address today is the appellant's lack of standing to even raise this argument. Obviously, I agree with the arguments that Mr. Wolf has just cited. However, I don't believe that the appellant even has the ability to ask this court or the lower court to vacate a judgment despite the grounds, whether it's on equitable grounds or on jurisdictional grounds. I don't believe they have the proper standing. The appellant is a third-party purchaser. They purchased the property at foreclosure sale, so they are not a party to the case. They have not even attempted to intervene as a party to the case. However, what they're attempting to do is derive standing on the basis of a quasi-party. Now, they cite 4 cases in their reply brief in which they indicate gives them the authority as a quasi-party to ask this court to vacate based on subject matter jurisdiction. I don't think any of those cases actually indicate that. The first case they cite, Lawrence v. Marina Tower, is a post-judgment issue. Third-party purchaser is given the right to act as a quasi-party to handle a sanctions issue with another party post-judgment. At no time are they trying to vacate a judgment, vacate a sale. The other 2 cases in the progeny are the Stratton v. 6000 Indian Creek and Miller v. Stavros. Both of those are also post-judgment issues. The Stratton case is one in which the third-party purchaser is trying to get rid of possession. The court says you have the ability to get rid of possession even though you're not a party to the case. Miller v. Stavros, same thing. The third-party purchaser is attempting to disperse surplus funds. So again, a post-judgment, post-sale issue, not trying to attack the judgment that occurred in the case. The final case that was cited by Mr. Skelton is Arsali v. Deutsche Bank. If you read what was cited via Arsali v. Deutsche Bank, it does seem to kind of convey some sort of standing. However, if you actually read that case, that is another case where a foreclosure sale occurred. A third-party purchaser comes in and purchases it. That case, the bank actually figured out that they made a mistake in the sale. They unilaterally vacate the sale. They don't inform the third-party purchaser. The court in that matter said, you do have enough standing to appeal that decision, but you don't have standing to vacate the judgment. In fact, that case, the third-party purchaser wanted the judgment, wanted the sale to stand. One thing that Mr. Skelton did not reference is that there is actually a second Arsali case. A year after Arsali v. Deutsche Bank, there is Arsali v. Chase Home Finance. That same third-party purchaser is now trying to intervene into another foreclosure action. And the court was very clear that an intervener is bound by the record made at the time they intervene. They must take the suit as they find it. They cannot contest plaintiff's claim against the defendant. They cannot challenge the sufficiency of the pleadings or the propriety of the procedure. We would argue that's exactly what the third-party purchaser here is trying to do, is set aside the judgment, whether, again, on equitable grounds or on jurisdictional grounds. We don't think they have the standing to do that. In fact, we cite a case that we believe is directly on point, Thriving Investments LLC v. Chow. That case, foreclosure sale occurs, a third-party purchaser purchases it, realizes they just purchased a second lien that is subject to a first lien. They ask the court to vacate the judgment, and the court says, no, you are a third party, you're a stranger to the foreclosure action, you lack standing to vacate a final judgment. In that case, the court even says the general rule is that a non-party is a stranger to the record who cannot transfer jurisdiction to the appellate court. So, Your Honor, we believe that as a third-party purchaser, they don't even have the standing to try and ask the court to vacate a judgment, regardless of the grounds, whether it's jurisdiction whether it's equitable
You would
grounds.
agree that they have standing to, is it your position that they would have to intervene to raise an irregularity in the sale? That they don't
Absolutely,
have
because right
stand-
now they are not a party to the case. So I believe if they want to raise this sort of ground, they would need to intervene, become a party to the case, and at that point they could then
And
challenge.
you wouldn't disagree that if they had raised an irregularity in the sale itself or pertinent to the sale procedure, that they would otherwise lack standing to intervene.
Right, so if they were only trying to vacate the sale, I think that would be different. In this case, they're trying to vacate the judgment. If they were only moving to vacate the sale, yes, I think our argument would be very different in that they can't establish the grounds to vacate a sale. But here they're actually asking to vacate the judgment. So I think that's kind of where the difference is. With that, I don't have any other things to discuss in regards to standing. So I'll leave it open to the court if you have any further questions. Otherwise, I'll thank you for your time and allowing us to present argument here today.
Very good. Mr. Shelton, you have your rebuttal time.
Thank you, Your Honor. I'd like to get back to the issue of the trial court's jurisdiction. And let's assume that it does have jurisdiction. At what point in time is the court's ability to enter a final judgment restricted by the language of 4823, which says that enforcement, the filing of the lis pendens bars the enforcement. So if it bars the enforcement, while the court may have jurisdiction up to a certain point in time, in order for the statute to have any meaning, there would have to be a point in time where it is barred from actually granting the relief. So,
but it wouldn't be barred from denying the relief. Is that your position?
It wouldn't be barred from denying the relief that the plaintiff was seeking, no.
What about the relief that Koch was,
Well, if the court has jurisdiction, then of course, it certainly wouldn't prevent them from denying.
And we've already agreed that if that were this case, then the constructive knowledge becomes a huge problem for your client.
Well, I don't think so, in the sense that if at some point in time the court is barred from the enforcement, then it's not really an equitable matter, it's a matter of law. So again, I guess I questioned, again, how far can the trial court in the Cruz case go based upon the statute? Even if you assume it had jurisdiction, it must stop at some point in time, or the language of the statute would have no meaning.
What if we know this happens, what if the Bank of New York foreclosure lasts for 15 years? I don't see anything in the statute other than the 30 days that would say, and at the end of 10 years, nobody can enforce.
Well, again, that creates the problem for allowing the trial court in this case to have jurisdiction. Again, what happens 15 years from now? Do you go back to the trial court in the Cruz case and say, hey, the final judgment was entered in the Bank of New York case, therefore your judgment is no longer valid? I think that creates a can of worms that this court doesn't really need to address. Again, unless it wants to find that it has jurisdiction, well, then I guess we're going to have to deal with the problem you've just raised. Now, as far as does this court have, well, strike that, does my client have the right, the standing to appeal this case? I think the answer is yes. Again, the Arsali versus Deutsche Bank case said that. I think they went to great lengths to collate all of the various courts of appeals opinions on that. If they have standing in the lower court, then I believe as a quasi-party, and really I think the second district is the only court that has not actually rendered an opinion on that. But based upon the other four DCAs, my argument would be that if Koch has standing in the lower court, then as a quasi-party, then it has standing to appeal, particularly in this case where it is aggrieved by a judgment in foreclosure that it contends the court had no jurisdiction to enter.
Anything else, Mr. Stelpen?
No, Your Honor.
Very good. So absent any questions from the panel, that concludes this case. Thank you all very much for the arguments today. We appreciate it. You may now exit the courtroom.